Okay, we are live now. Very good evening to all LLA exclusive members, and welcome to the last webinar of 2020. And you would be surprised by seeing me. मैं हमेशा ऋषभ सर होते हैं, but आज मैं हूँ because he could not be there due to some personal uh, commitments, if you will. So let's begin. We have our guest with us, Mr. Shashikant Bhanudas Savale. सो इनके बारे में मैं जितना बोलूं मुझे लगता है मैं जस्टिस कभी नहीं कर पाऊंगा एंड सर ऑनेस्टली यू हैव अचीव्ड सो मच इन योर करियर सो प्लीज अपॉलॉजीज इन एडवांस अगर मैं कुछ मिस आउट कर दूं आपने you joined as a judiciary judge in 2000, then you worked as a chief judge in small cause court Mumbai. You have also had the pleasure of being the president of cooperative appellate court Mumbai. Then you went on to become charity commissioner of Maharashtra, and then you became the president of industrial courts. उसके बाद आप नागपुर के एक प्रिंसिपल डिस्ट्रिक्ट जज भी थे एंड वहां से आपने एट द एज ऑफ 62 रिटायरमेंट लिया एंड नाउ you refuse to retire and you are a practicing lawyer. Sir,
thank you, sir.
I apologize if I wasn't able to do justice, but sir, very two very important accomplishments that you have made in your career is you proposed amendments to some major laws, one of them being Industrial Code Regulations 1975 regarding labor code and procedural rules. Sir, सबसे पहले I'd like to know. I mean, we all would like to know कि आपने क्या amendments propose किए थे and क्या-क्या उसमें से amendments accept हुए.
Basically, so far as the amendments in the unfair labor practices cases, when I became the president of the industrial code, I found that the cases are getting delayed so much that in one case particularly, I remember the issue was regarding his illegal termination, according to him, and the case was prolonged to such an extent that when he became successful, he had attained his age of retirement. So 15 years he took in the labor and industrial court.
Okay.
So this was, then I went to the root of that. Why this is so? When the law expects hearing of a case to be completed within 6 months, why this much time? I will later discuss this in detail. We'll go to the, but I could find out exactly the problem, and then to overcome it, the amendment was proposed. Now, to cope up with these type of cases, right from the stage of issuing notices till the hearing is completed, the amendments have been proposed. I will discuss it later in my speech. But this has a very magnificent effect. Now at Mumbai, such cases where the termination or any sort of unfair legal practice is challenged, the cases are in a position of getting disposed within 2 or 3 years. At labor court stage, it is disposed within a year. And in the industrial court, if the appeal is preferred, the case is disposed of within 6 months to 1 year. So the period has been reduced to this extent now. So there is some substance now in hearing the complaint. Otherwise, it was really a mockery that a person gets a relief after 15, 16 years when he's...
I can imagine, sir. In so many cases, not just in labor and industrial community, but almost everywhere. And do you think it's because we have an acute shortage of judges in India?
No, in fact, I don't feel so. There is no there is no question of shortage. The question is of procedural. I think the word perhaps I can, as an advocate, now definitely use procedural mockeries. I say.
Understood, sir. Understood. So all thanks to you, now the case duration has been brought down to not 15 years, but 2 to 3 years.
Yeah, certainly.
Amazing, sir. That's really amazing. So, sir, if you may, we would like to have this conversation in English, if you're comfortable. Some in Hindi, some in English.
मैं हिंदी में भी बोल सकता हूँ क्योंकि मेरी बहू हिंदी है. एक्चुअली आई एम ए मराठी पर्सन, बट
ओके
नाउ वी आर टॉकिंग हिंदी ऑलवेज बिकॉज शी इज फ्रॉम दिल्ली.
ओके ओके. सो ठीक है सर, क्योंकि हमारी मेजॉरिटी ऑडियंस इज हिंदी स्पीकिंग ऑडियंस,
ओके,
एंड इट वुड बी मच मोर बेनिफिशियल फॉर देम.
मैं हिंदी में बोल सकता हूँ, मुझे कोई दिक्कत नहीं
ओके.
है.
सो आज हम सर डिस्कस कर रहे हैं अनफेयर लेबर प्रैक्टिसेस एंड हाउ यू मे हैव अ रेमेडी फॉर देम. Okay.
Yeah,
So,
yeah,
sir, the stage is yours, sir.
yeah.
Yep.
I will perhaps in explaining legal aspects I will be in English, or otherwise I
No
will
problem. No
speak in
problem, sir.
Hindi. अनफेयर लेबर प्रैक्टिस, इसका तो कोई भाषांतर नहीं हो सकता है इतना
नहीं हो
सही,
सकता.
क्योंकि इवन इन इंग्लिश आल्सो this
Mhm.
word has never been defined in any act. It is always subject to the description made in the act.
Mhm.
That is an interesting aspect. We'll go to it later on. So हिंदी में तो हम इसको अनफेयर लेबर प्रैक्टिस कहेंगे.
Mhm.
अनफेयर लेबर प्रैक्टिस की एक बड़ा इतिहास है अनफेयर लेबर प्रैक्टिस का.
Okay.
अनफेयर लेबर प्रैक्टिस जिसे हम आज बोलते हैं वो कई सालों से चलती आ रही है.
Mhm.
अंग्रेजों के जमाने से ये अनफेयर लेबर प्रैक्टिस का कंसेप्ट हमने महसूस किया है. जैसे मैं आपको एक उदाहरण दे सकता हूँ कि बिफोर इन 19th century ऐसे the India was having that way source of income from agricultural lands only.
Mhm.
The process of manufacturing was being done by the workers manually. जैसे एक कारपेंटर कोई अ, लकड़ी की चीज बना सकता था, एक लोहार कोई लोहे की चीज बना सकता था. इवन
Mhm.
तलवार, ये जो ढाल, जो शस्त्रास्त्र थे उस जमाने के, वो भी इसी प्रकार से मैन्युअली ही बनते थे. सो देर वर
Mhm.
प्रैक्टिकली नो इंडस्ट्रीज एज सच. सो द मेन
Okay.
इंडस्ट्री वाज एग्रीकल्चरल इंडस्ट्री. एग्रीकल्चरल इंडस्ट्री भी पूरी एक तरह से जमींदारों के कब्जे में थी. हम लोग
Right.
कई पिक्चर्स में, मूवीज में भी देखते हैं कि किस प्रकार जमींदार वर्कर्स पर हावी हो जाते थे, किस प्रकार
Mhm.
वो उन पर जुलूम करते थे.
Right.
और दिस इज आई थिंक अनफेयर लेबर प्रैक्टिस. वी कैन इन अ वेरी सिंपल लैंग्वेज डिफाइन, बहुत सोपी सरल भाषा में, जो जुर्म या जो गैर कानूनी बातें इम्पोज की जाती है वर्कर्स पे, इसे हम
Mhm.
अनफेयर लेबर प्रैक्टिस बोल सकते हैं. सो
Okay.
19वीं सदी में जो बातें चल रही थी, ब्रिटिश लोगों के आने के बाद वो शुरुआत में काफी ज्यादा बढ़ती गई. बट इन लेटर पार्ट ऑफ 19th century and then of early part of 20th century, the British people brought civilization in it. They try
Right.
to cope up with the relay. They try to make the workers and the owners understand each other.
Mhm.
So with this, the concept of unfair labor practice was started to be getting reduced by the British people. Now, so
Mhm.
far as the industrial, I will be more comfortable in English. बीच बीच में मैं
No
हिंदी,
problem.
बीच
Okay.
बीच में हिंदी बोलते रहूंगा समझाने के लिए.
ठीक है सर.
So in early part of 20th century, there was a first legislation to control these unfair labor practices, and it was National Labor Relations Act, which was passed in 1935, the British period. That act that way was not exhaustive. It was not able to take enough care of the smooth relations between the employers and employees.
Mhm.
Therefore, there was a continuous process was going on to make the relations smooth between the employer and the workers. There was another attempt in 1946 when Labor Management Relations Act was brought. It was also that way not very successful, and therefore in Maharashtra, see, it's a very interesting aspect. Other than the states in India, that at that time the states were not even formed. There were provinces. British people have marked some parts of the country as provinces. So that time, Bombay and Gujarat were one. Bombay and Gujarat were forming a state of Bombay, and that part of the country was that way leading in industries. It
Okay.
had an advantage of ports also. Gujarat
Okay.
also had a port, so there was a very convenient mode of importing and exporting the goods necessary for manufacturing. So Bombay and Gujarat, that was the Bombay state. It was leading. There were many industries, there were many workers, particularly the cotton industry was leading that time.
Mm-hmm.
Even other industries, food industries were also there to some extent. Masala products, etc., were being produced that time. So in those days, also when it was continuously realized that the workers are not happy, the capitalists were investing their funds for establishing the factories. So they were more interested in getting more and more profit, exploring more and more profit. Therefore, they used to exploit the workers, laborers.
Okay.
The, the position, in fact, the jurist or some other good people thought that if the relations are smooth, the yield can be more. But this could not be understood by those employers or manufacturers. And therefore, in the form of law, this position was thought to be imposed. And
Mm-hmm.
therefore, in 1947, Bombay Industrial Relation Act was framed, and for the Bombay state, this act was made applicable. Bombay Industrial Relations Act.
Okay.
At the same time, at the national level, Industrial Disputes Act was also brought into force. But even after these two laws, these two acts, the situation was not under control. There were disputes, particularly you might have seen even in many movies also, that cotton mills had more problems.
Right.
Cotton mill workers were being exploited, and there were many दंगा फसाद उस एरिया में उस समय में बहुत चलते थे, जुल्म होते थे, कई बार कत्ल हो जाते थे एम्प्लॉयर की तरफ से। इस प्रकार
Mm-hmm.
की एक बहुत अनहैप्पी सिचुएशन थी। सो उसको कंट्रोल में लाने के लिए फिर कोशिश चलती रही, और महाराष्ट्र में फिर 1971 में ये एमआरटीयू एंड पीयूएलपी, दिस इज अ शॉर्ट फॉर्म, दिस इज नोन एज महाराष्ट्र रजिस्टर्ड ट्रेड यूनियंस एंड प्रिवेंशन ऑफ अनफेयर लेबर प्रैक्टिसेस एक्ट वाज ब्रॉट.
Okay.
So this type of acts are even at the other states also. There are in other states also. I have not studied them. I have come
Mm-hmm.
across only the Maharashtra. Sorry, Madhya Pradesh has some similar act. So,
Mm-hmm.
but the MRTU and PULP Act, in short, as I said, was brought in 1971. So
Okay.
now the position is that in Maharashtra, there are three different acts. Bombay Industrial Relations Act,
Mm.
which is applicable to few types of industries, particularly industries which are in the Bombay area. So those few industries were being governed by the Bombay Industrial Relations Act. So far as the remaining industries are concerned, they were being considered under the Industrial Disputes Act.
Mm-hmm.
And then when MRTU and POLP Act was 1970 was brought in 1971, there is a uniformity at least to adjudicate the unfair labor practices. But
Right.
still, those few industries which are governed by the Bombay Industrial Relations Act, for example, I can say if Tata has some industries in Mumbai, Reliance has some industries in Mumbai,
Mm-hmm.
depending on their capital limits, these type of industries are covered by the Bombay Industrial Relations Act, others by the Industrial Disputes Act till
Mm-hmm.
1971, and now this, so far as the unfair labor practices are concerned, this Act of 1971 takes care of. Now, this
Okay.
Act has one more additional feature. This Act recognized a procedure of registering trade unions. This is a very important because trade unions have a very important role in this coping relations in between employer and employee. See, one poor worker, one poor workman may not be able to fight with the industrialist or employer.
Mm-hmm.
But if he approaches a union, the union can represent him. So this is
Right.
a very particular feature. See, generally we know the general law says that in under Indian Penal Code, we can take an example that a person who has been really aggrieved can only file a complaint. So there cannot be a representation of any person aggrieved, offended under the Indian Penal Code. But under this particular act, there can be a representation of such an aggrieved person by the union. So
Okay.
there may be one aggrieved person, there may be two, there may be more. So the union can now, as a collectively, represent the aggrieved worker. This is advantage of this formation of unions. Of course, the unions were there, but
Mm-hmm.
there was no clear provision of making registration of the unions, making some restraints also on the unions, because
Mm-hmm.
sometimes unions are also found to be taking law in their hands. So
Right.
to overcome this, there was a necessity of putting some restraint on the unions also.
Mm-hmm.
Therefore, now this Maharashtra Registration of Trade Union Act takes care of this situation. I know that
Mm-hmm.
there are similar acts are there in different states also which register union. Indian Trade Unions Act is also there, which is a central act which covers the entire country. So the advantage is now the grievance of the workers can be represented by the unions. This is the best position, I think, according to me, to bring harmony in between the employer and employees now.
Mm-hmm.
Now, this is in general the history, I have said, history of the unfair labor practices, the how they were going on and how they workers were being protected from that under the
Mm-hmm.
various laws they were. But now the question is, what is exactly meant by the unfair legal practice? This has to be understood.
Okay.
हिंदी में समझाना चाहता हूं मैं, अनफेयर लेबर प्रैक्टिस कोई भी गलत बात हो गई तो वो अनफेयर लेबर प्रैक्टिस नहीं हो सकती.
Okay.
कोई it is not necessary that every unfair labor practice may be illegal.
True.
उदाहरण के तौर पर मैं एक केस मेरे सामने आई थी वो बता सकता हूं मैं.
Mm-hmm.
एक एक वर्कर, उसकी जन्म की नोंद, जन्म तारीख जिसे बोलते हैं हम,
Mm-hmm.
रिकॉर्ड पर 1954 लगी थी, whereas his actual date of birth was 1952.
Okay.
So he was retired 2 years before.
Mm-hmm.
Now, till that moment, he did not take any step. Even after retirement for 1 year, he did not take any step. So
Mm-hmm.
his conduct was such that he never pretended or he never fight out for the wrong entry of his date of birth in the record.
Okay.
इनफैक्ट जो जो सही जन्म तारीख थी उसकी, वो 1952 1954 ही थी, मगर वो 1952 की हिसाब से रिटायर कर दिया गया 2 साल पहले.
Mm-hmm.
Now, according to any man, even according to general law, it would be illegal.
True.
But it has not been considered as an unfair labor practice. The reason
Okay.
was that he accepted his date of birth as 1954 since the beginning. He did not challenge it. He realized somewhere when he was retired, he realized he found out the record and he realized that his date of birth is 1954 and not 1952.
So he did not
So
even realize that he.
this is though an illegality, it is not unfair labor practice because the employer at no point of time took law in his hand, did anything which is which can be styled as unfair. Yes, क्या चाहते हैं आप, क्या पूछना चाहते हो?
सर मैं ये पूछ रहा था कि व्हाट इफ ही हैड चैलेंज्ड इट, उस समय क्या होता?
Had he challenged long before, had he challenged
Mm-hmm.
long before, because when he accepted service, his service record was in his hands.
Mm-hmm.
He had noted that his birth date is shown to be 1954, not 1952. So there was
Mm-hmm.
ample time in his hands to make a representation to make the correction in the service record.
Okay.
After retirement, he comes with a grievance. After 1 year of retirement, he comes with a grievance. So this conduct on his part was amounting to estoppel practically. So
Okay.
therefore, what I wanted to canvass is every illegality there may not be any illegality, but there can be an unfairness.
Okay. Understood.
Unfairness is a behavior of the employer which does not sound good to any man of reasonable prudence as a good conduct, good practice.
Okay.
One thing. Secondly, it would appear to be unfair in light of the service conditions with which the employee was joined in service. So that
Mm-hmm.
is we can call as unfair
Mm-hmm.
labor practice. So this is this now therefore what the act has done, Industrial Disputes Act says that only those acts which have been described in Schedule 5 are unfair labor practices.
Okay.
Now, to a man of to a common man, it would also sound something awkward. See, normally in other type of cases, we go before the court of law, we put our grievance, and it is the judge who considers, taking into consideration the circumstances, that whether a particular person has suffered wrong.
Mm-hmm.
Now, here in case of unfair labor practices, only those practices who have been described in Schedule 5 are considered as unfair labor practice.
Okay.
Beyond that, if any sort of other, see, this Schedule 5 is also that way illustrative. It is not exhaustive. It does
Mm-hmm.
not cover all types of unfair labor practices which can happen in case of any person in future or unknown to any previous incident.
Mm-hmm.
So what the act has done is that the president of the industrial court has given power to take a note if he comes across a case where the unfair practice which has been alleged to have been carried against that employee complainant, if he is not finding place in Schedule 5,
Mm-hmm.
he can take a note of it and he can make a request, then he can make an amendment to include that type of act in the list of unfair labor practices. But
Okay.
till that is not brought under the act, that type of conduct of employer will not be considered as unfair labor practice. I think according to me again a lacuna. Perhaps it may be a protection might have been given by making such a provision. Protection to the employer.
Hmm.
See, if the before the judge any complaint is filed, and if the judge, as per his whim, decides, then there may be a variety of unfair labor practices.
Right.
There would be a chance of unnecessary declaration of an employer to be a wrong person, a person who has followed unfair labor practice. So,
Hmm.
to avoid that, I think the Act has made a specific provision that those who are listed only can be considered as unfair labor practices. Now, a very interesting example I would give you to explain. See, if a if the labor court or industrial court has passed an award,
Hmm.
that award if is not followed or obeyed, then there would be a contempt of the order of that particular court by the
Hmm.
employer. Now, the difference in between that, very interesting, you may note, please. Under the Maharashtra this MRTU and PULP Act, now, as I said, there is a section 48 under which the complainant who in whose favor some award is passed and is not obeyed can approach to the labor court or the industrial court and get his award which has been passed in his favor executed.
Okay.
If he makes another complaint with a grievance that the award has not been executed, so that is also according to him is an unfair labor practice. In Maharashtra, such type of second complaint will not be entertained. The High Court of Maharashtra says that once you have obtained an award, you get the award executed. But under the
Hmm.
Industrial Dispute Act, that can be considered. See, this is very, I would
Okay.
put it, very
So
interesting situation.
which one do you favor personally?
Huh?
Which one do you favor personally?
See, under the fifth schedule of this Industrial Dispute Act,
Hmm.
failure to implement award, settlement, or agreement has been considered as unfair labor practice, whereas in Maharashtra it is not. So,
Okay.
under the acts also there are some differences, varieties. This is the position of. So, what I wanted to emphasize is that unfair labor practice has to be always considered in light of this Schedule 5 under the Industrial Dispute Act. So far as in Maharashtra, there are five schedules under this Maharashtra Act. So the scope of making complaints has been enlarged in Maharashtra. That is
Okay.
why perhaps that is why perhaps the delay of hearing the complaints was much more in Maharashtra than other states.
Okay.
Therefore, this act was brought into effect. Even then, also the position is not very happy. Of course, that part will discuss in light of some case laws. Now,
Okay, sir.
now the next point which I would like to discuss is that there are various authorities now, even under the Industrial Disputes Act. See, the
Hmm.
law has made maximum care of the employees, laborers, and workers. Maximum care. Still, unfortunately, we are not been successful. Why we'll discuss in later parts. But what care that has been taken, we'll discuss. See, there are about 10 authorities under the Industrial Disputes Act. There are 10 authorities which take care of the workers. The first under Section 3 is the Works Committee. The
Hmm.
job of this Works Committee, the constitution of this Works Committee, which has been established for a particular industry, is to always supervise, monitor that there are good relations in between the employer and employee.
Okay.
If there are any chances of getting differences between them, it's the working committee who would take initiative and settle those disputes. That's the job of the working committee. Working committee is formed where there are more than 20 employees. So
Okay.
even in a case of smaller factories also, the committee is established. 50% is representation is given to the employer, 50% is given to the employees. And the
Okay.
working committees thus try to make the harmony in between them. Then the next, under section 4 of the act, a conciliation officer is appointed by the state. The
Okay.
job of this conciliation officer is wherever there is any dispute between the employer and employee, he would try to conciliate in between them.
Okay.
So without going to the court, excuse me, without going to the court, you may please give me an alert if I am exceeding the time. I
No,
would
sir.
try
No
to.
problem. No problem.
The conciliation officer then this undertakes this type of work. Then there is a board of conciliation also. Conciliation by one officer. Then there is a board of conciliation which is consisting of 5 officers, and they are appointed by the government, and representations from the employer and employee is also there. That board of conciliation also tries to settle the matter in between them. Then there are, under section 6, courts of inquiry also. One court, labor court is another. Labor
Mm-hmm.
or industrial court is another aspect. The courts of inquiry are appointed by the government, and one officer presides over it on the court contemplated under section 6 of the Industrial Dispute Act, which is a
Okay.
central act, as I said. Who here before him also the aggrieved person can go. Either individually he can go, or through the union also he can go. And
Okay.
that court of inquiry would also try to settle the matter. Then there are, under section 7, there are labor courts. The regular procedure as followed in the courts is followed by them. Of course, the nature of the inquiry is summary. We'll discuss about the procedure which is generally followed by the labor courts. Then there are tribunals, industrial tribunals, which act as appellate authorities over the labor courts. One, and in typical disputes, they are working as trial courts also. So they directly entertain. So there are different classifications in the complaints, in the nature of complaints. So the jurisdiction of industrial court and labor court is based on the nature of the complaint. This is one more relief that has been given. And then there is a national tribunal also. There may be industries at national level. One group, suppose Tata has industries all over India. So if dispute between the employer and employee of there are the employees of of the various industrial units of Tata in the country, if they are representing any union is representing for them, then it becomes a matter of jurisdiction of the national tribunals. So this is one more. Then appropriate government in this sense, state of every the state of where the industry is situated refers disputes. So any person aggrieved can approach to the authorities which have been appointed under section 10 by the appropriate government. He can approach them, he can put their grievance, and considering his grievance, after hearing even the other side of the employer also, they refer the dispute to these type of different authorities. So to avoid unnecessary and wrongful jurisdictions of the court, sometimes it happens no that the wrong court is approached. The
Mm-hmm.
employee or the unions do not know which court should be preferred. So to avoid that, the government has made this arrangement that
Mm-hmm.
that particular aggrieved union or the worker can approach this particular authority formed by the appropriate government, it hears and then it is, if unable to settle the matter, then it refers to a proper court.
Mhm.
Maybe either before a board or before a conciliating officer, before any investigating officer, or before a labor court or industrial court. So the chance of being thrown in a wrong court would be avoided by this particular provision. Then, at any stage, either after approaching the labor court or any other authority, or before that, the union or the worker can enter into our agreement of arbitration also, and then the arbitrator can be appointed and he can also solve the dispute. So these are the various authorities which can take care of the employee. And according to me, the most important care that has been taken by the government is by allowing a collective representation. This I have referred just a few times, a few minutes before. I would explain it in detail. ये जो यूनियंस रहती है ना, बहुत
Mhm.
लोगों का इसके बारे में मिसअंडरस्टैंडिंग रहता है। हाँ,
Okay.
कुछ हद तक सही भी है ये बात कि यूनियंस कई बार पार्शियलिटी करती है, उनके कुछ टिपिकल लोगों को फेवर करती है, या फिर यूनियन के लीडर पैसे लेके भी कुछ काम करते हैं या कुछ काम नहीं करते, या कई वक्त एम्प्लॉयर उसके फेवर के यूनियन लीडर बना लेता है। ऐसे 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 अनेक घटनाएं होती रहती है। बट
Mhm.
सी, whenever any act is to be done, there are side effect. Even a
Right.
medicine has a side effect.
Mhm.
Therefore, we should think and be happy with what good results we are getting. So generally, representation by unions give a very good relief to the workers, in the sense he has not to spend for the court's procedure. Otherwise,
Mhm.
in a city like Mumbai, it is very difficult. In a city like Delhi, Madras, it is very difficult to fight out any litigation. A simple litigation of family dispute goes into the terms of lakhs of rupees.
Right.
So that would be, if these unions would not have been there, perhaps the workers would not have been able to approach these authorities.
True.
Now, I am an advocate, I need not criticize, but many times advocates' expenditure also sometimes goes to much extent in a city, in the cities like this, Mumbai, Delhi, etc. Of course, everything has been very costly, therefore they are also justified. The point
Mhm.
is, the point is, though the legal expenses of court fees, etc., are that way very short, but other expenses increase, traveling expenses and so. So all these expenses, if are taken into consideration, it is very difficult to approach courts for a common man nowadays. The
True.
unions make this. So the most happy part of this is that from a very minor subscription paid monthly by the members, the worker,
Mhm.
he gets a relief of lakhs of rupees when he faces any sort of grievance.
It's just like insurance.
I'm explaining this in more words because ये मैंने अभी कहा जैसे हिंदी में, ये बहुत बहुत लोगों के इसके बारे में बहुत मिसअंडरस्टैंडिंग रहते हैं सर।
Mhm. True, sir.
आप कुछ इसके बारे में पूछना चाहते हो सर?
सर मैं ये
कम
कह
से
रहा था
कम।
कि इट्स जस्ट लाइक इंश्योरेंस, एवरीबॉडी चिप्स इन
हाँ,
ताकि
या
जिस दिन जिसको जरूरत हो
एग्जैक्टली,
उसके काम आ सके।
या एग्जैक्टली, वी अवॉइड टेकिंग इंश्योरेंस बट वी रियलाइज इट्स इम्पोर्टेंस व्हेन वी फेस
It's
एनी
important.
प्रॉब्लम अनटोवर्ड प्रॉब्लम।
Sir,
So
we
that
have a
is,
question from one of our members. Uh,
hmm.
it is not formatting workers committee in company. Uh, in this case, is there any penalties from labor department? अगर workers committee ही establish नहीं करी हो किसी company में, तो what are the
Yeah,
penalties?
there are penalties. There are procedures for compelling it. So this is a
Uh-huh.
mandatory provision. Mandatory provision for every
Okay.
industrial establishment. There has to be the section. If we read, it says shall. And see all these acts. I can tell you the Factory Act. All there are about 22 acts. So surprisingly enough, in India, so far as the laws protecting the laborers, they are in numbers around 2400.
Oh my God.
Oh. And it's very interesting that when I became the industry, that way I was from a judiciary. I
Mm-hmm.
was deputed on this post.
Mm-hmm.
So the complications, the laws, there are many laws. So while deciding a particular case, at least 7 to 8 laws are to be referred. So
Right.
that makes so in particularly Maharashtra, whether BIR Act, Bombay Industrial Relation Act applies, Industrial Dispute Act applies, MRTO Act applies, then other aspects also, gratuity, bonus, and so many. In a single case, there are references of many acts. That is why now in 2021 we are getting a new code of relations that would, I
Mm-hmm.
think, be curtailing much of these laws, number of these laws. The point is, the point is, we therefore must have a membership. Every employee, every workman must have a regular membership of any union which is attached, and every industrial establishment has a such type of union. There may be even there are in some cases where the industries are big. There may be 2 or 3 unions also.
Mm-hmm.
Sometimes there are clashes also among the unions. That is another aspect. The point to be canvassed is that one should be a member of any such union. This is
Right,
one
sir.
aspect. This is one aspect of this. Now, the next part is after exhausting all these remedies, nothing has been coming in the hands of an employer or worker. The
Mm-hmm.
last remedy is to approach the labor court or the industrial court.
Okay.
Now, as I said, the labor courts and industrial courts are not in a position to give relief. So far as Maharashtra, the change position I have brought to your notice. But still, it is not in all cases that 2 or 3 years period is enough for getting decision of. Many cases are still being prolonged.
Mm-hmm.
So here I think we should it is for all of us to be very cautious. See, all of us, I mean all judges and advocates who are representing you are dealing with these cases. So
Okay.
procedural mockeries, I said, procedural mockeries, I said. The procedural mockeries no are many times because of the mistakes committed either by the advocates or the judges.
Okay.
Sometimes the advocate fails to note a particular provision in law.
Mm-hmm.
Sometimes the judge, though matter is argued properly before him, ignores that particular provision of law. So the
Mm-hmm.
side effect results into procedural mockery.
Okay.
In fact, it is a summary inquiry. हिंदी में समझाने के लिए मैं बोलूँगा कि इनको जो कोर्ट में जो केसेस चलते हैं, उनके अलग-अलग प्रकार होते हैं। क्रिमिनल
Mm-hmm.
केस अलग ढंग से चलती है, सिविल केस अलग ढंग से चलती है और ये इंडस्ट्रियल कोर्ट्स में के जो केसेस है, दे आर इन फैक्ट समरी, मतलब बहुत ही ईज़ी तरीके से जैसे जज के सामने किसी ने अपनी कहानी सुना दी, दूसरे ने अपनी कहानी सुना दी और जज ने उन दोनों की कहानी सुनने के बाद ने फैसला कर दिया। इतना आसान माना जाता है।
Okay.
जो हम लोग देखते हैं मूवीज में भी या हम कोर्ट्स में जाते हैं तब देखते हैं कि कोई साक्षीदार एक शब्द बोल रहा है और कोई लिख रहा है।
Uh,
वो बोलने की और लिखने की जो प्रोसीजर होती है वो इतनी लंबी होती है कि एक साक्षीदार की जबानी कई बार 10-10 दिन तक वो नोटिंग डाउन चलता रहता है। So
okay.
this type of procedure is not contemplated. समरी इंक्वायरी का मतलब ये है, मैं हिंदी में अगर और समझाऊंगा। समरी इंक्वायरी के लिए कोई ट्रांसलेशन, संक्षिप्त न्यायालयीन चौकशी ऐसा बोल सकते हैं शायद।
हम्म,
संक्षिप्त का मतलब ये होता है कि इसमें जज सुन लेगा और उसके नोट बनाएगा। एक
हम्म,
साक्षीदार ने जो बोला है वो सुन लेगा और उसके एक शॉर्ट नोट बनाएगा। दूसरे की जो कहानी है वो सुनेगा, एक शॉर्ट नोट लेगा। पर हमारे कोर्ट्स में जो प्रोसीजर आज जो होती है, वी आर टेकिंग डाउन एडवर्बैटिम वर्शन ऑफ एवरी विटनेस। शब्द और शब्द हम लिख लेते हैं साक्षीदार का, जो इनफैक्ट नेसेसरी नहीं है। दिस इज प्रोसीजरल एरर आई कैन से। तो इसलिए मैं आपको इस आपने जो ऑर्गेनाइज ये प्रोग्राम्स किए हैं इसके बारे में आपको धन्यवाद इसलिए दूंगा कि दिस टाइप ऑफ वेबिनार्स आर इंस्पायरिंग एंड एक्टिवेटिंग ऑल एडवोकेट्स ऑन वन पार्ट। देयर मे नॉट बी litigants who are participants in this program, but at least
हम्म।
advocates are there. There may be judges also. So we should become expert in this subject. That is very necessary.
ट्रू सर।
We should not try the subject. We should understand the subject from the very moment when we take the case in our hand. ट्रायल एंड
राइट।
एरर मेथड नहीं नहीं होना चाहिए इस टाइप ऑफ, इस प्रकार की केसेस में किसी वकील ने ट्रायल एंड एरर मेथड नहीं करना चाहिए। और जजेस ने,
स्पेशली।
हाँ क्योंकि होता है, मैं ये इसलिए बोल रहा हूँ कि कई बार जैसे मैंने भी शुरुआत की वकीली में, तो मैं तो कुछ मेरे जैसा मैंने पढ़ा, जैसे मैंने सोचा उस प्रकार से मैं वकालत करता था। छोटी
राइट।
मोटी केस मेरे दिमाग में जैसे समझे वैसे करता था।
हम्म,
एरर्स आते थे,
हम्म।
एरर्स आते आते एरर्स करते करते हम लोग सीखते जाते हैं। मगर इस टाइप के केसेस में मेरी एक रिक्वेस्ट है कि दी न्यू लॉयर्स आल्सो शुड लर्न द लॉ बाय हार्ट। तो दिस इज नॉट अ जस्ट, मैं कुछ प्रवचन नहीं दे रहा हूँ, ये फिलॉसफी नहीं बोल रहा
नहीं
हूँ।
सर, आई टोटली
दिस इज
अंडरस्टैंड।
ए नेसेसिटी।
It's a matter of responsibility. If
रिस्पॉन्सिबिलिटी।
if someone calls themselves a lawyer, they should be responsible enough to handle such cases. नहीं तो किसी का 15 साल खिंचता है, someone has to wait and all, वो सब होता है।
जैसे मैंने ये बताया ना एग्जाम्पल आपको, 15
हम्म,
साल के बाद वो, तो ये
हम्म,
15 साल तो क्यों हुए, एक वजह मैं अभी आपको बता देता हूँ। क्या
हम्म,
है ना कि एक इंटरेस्टिंग पार्ट है, जैसा आप सिविल केसेस में रहता है,
हम्म,
जो सिविल कोर्ट रहता है वहां पर एविडेंस रिकॉर्डिंग होता है।
हम्म।
जो भी एविडेंस कलेक्शन है, वो डॉक्यूमेंट कलेक्शन है, वो सब सिविल कोर्ट में हो जाता है। उसके बाद अगर केस डिसाइड हो गई और कोई पार्टी अपील में आई, तो अपील में जो नीचे एविडेंस कलेक्ट हुआ है उसी पर निर्भर होकर अपेलेट कोर्ट डिसाइड करता है केस। बहुत
ओके।
रेयरली कोई एडिशनल एविडेंस लिया जाता है। हमारे
ओके।
महाराष्ट्र में क्या होता था, आपको एक प्रोसीजर के पार्ट, ये किसी भी लेबर कोर्ट के इंक्वायरी में ये रहती है कि इंक्वायरी करता है एम्प्लॉयर का ऑफिसर, उसको हम इंक्वायरी ऑफिसर बोलते हैं।
हम्म,
मैं थोड़ा सा अलग ट्रैक पे गया हूं, मगर फिर भी ये इंपॉर्टेंट है इसलिए डिस्कस यहीं पर कर रहा
श्योर।
हूं।
हम्म,
शॉर्ट में डिस्कस करूंगा कि इंक्वायरी ऑफिसर जैसे कोई गवर्नमेंट सर्वेंट्स के बारे में होता है, वो स्टेट
हम्म।
गवर्नमेंट के लॉज के अनुसार अगर कोई कर्मचारी गलती करता है तो उसको नौकरी से निकालना है या नहीं निकालना है, इसकी एक इंक्वायरी होती है। वैसे ही किसी भी इंडस्ट्रियल एस्टेब्लिशमेंट के वर्कर को सर्विस में रखना है या नहीं रखना है उसके कुछ गलती की वजह से, ये डिसाइड करने के लिए एक इंक्वायरी ऑफिसर इंडस्ट्रियल एस्टेब्लिशमेंट के मतलब एम्प्लॉयर नियुक्त करता है।
ओके।
वो जो एविडेंस कलेक्ट करेगा उसी एविडेंस पर निर्भर होकर लेबर कोर्ट ने सिटिंग एज एन अपेलेट कोर्ट डिसाइड करना चाहिए केस।
हम्म,
और हमारे यहाँ क्या होता था, महाराष्ट्र में तो भी मैं कह सकता हूं कि लेबर कोर्ट में जो एविडेंस इंक्वायरी ऑफिसर ने कलेक्ट किया है वही एविडेंस दोबारा रिकॉर्ड होता था।
ओके।
मतलब जो प्रोसीजर वहां इंक्वायरी ऑफिसर ने साल भर में की, वही प्रोसीजर रिपीट होती थी, और उसके लिए 2 साल 3 साल 4 साल 5 साल कितना भी समय लग जाता था। क्योंकि वकील हाजिर है, वकील गैर गैर हाजिर है, ये लोग सब आप तो जानते हैं कोर्ट में किस
हम्म,
प्रकार अटेंडमेंट्स होते रहती है।
हम्म,
दिस वाज द रीजन अब हमने जो अमेंडमेंट प्रपोज की है, अभी आपको एमआरटीयू एक्ट में जैसे अनफेयर लेबर प्रैक्टिसेस, महाराष्ट्र के एक्ट में जो अमेंडमेंट की गई है वो
Mm-hmm.
ये है, स्पेसिफिकली इट हैज बीन मेड क्लियर दैट वॉट एवर रिकॉर्ड हैज बीन प्रिपेयर्ड बाय द इंक्वायरी ऑफिसर ड्यूरिंग द कोर्स ऑफ इंक्वायरी, there will be
Mm-hmm.
no addition in it before the labor court. The labor
Okay.
court will consider it on the basis of the record created by the inquiry officer. इसका,
Okay.
इस अमेंडमेंट के बाद मैं इतना ये फर्क हो गया कि नाउ देर इज नो मल्टीप्लिसिटी ऑफ रिकॉर्ड, देर इज नो मल्टीप्लिसिटी ऑफ डॉक्यूमेंट्स एंड एविडेंस। तो केस आसान हो गया, जल्दी डिसीजन होना आसान हो गया उस बात की वजह से। हर एक बात का लिमिटेशन भी रखना चाहिए, रिटर्न स्टेटमेंट कितने दिनों के बाद आनी चाहिए, या नोटिस सर होने के बाद किस प्रकार से नोटिस उस पर जल्दी सर्व की जाए एट ए टाइम।
Mm-hmm.
जैसे सिविल प्रोसीजर कोड में क्या होता है, पहले यू हैव टू सर्व थ्रू ए रेगुलर बेलिफ, देन इफ
Mm-hmm.
रेगुलर बेलिफ इज अनेबल टू सर्व, देन बाय सम अदर मेथड ऑफ
Mm-hmm.
post etc, registered post etc, and the publication by newspaper is a last remedy।
Okay.
वैसा अभी नहीं रखा है, ये all these steps for public serving notice can be exhausted at a time। इस प्रकार की कुछ ऐसी अमेंडमेंट्स ये हुई है अभी एमआरटीयू एक्ट में,
Mm-hmm.
इसकी वजह से प्रोसीजर स्पीडी हो जाए। तो पॉइंट इज दैट वी ऑल शुड बी नाउ वेरी अलर्ट एंड अवेयर। तो इन जिन स्टेट में इस प्रकार की अमेंडमेंट नहीं है, वहां पे भी सुप्रीम कोर्ट के पहले से इस पॉइंट पर डिसीजंस है। ये जो अमेंडमेंट प्रपोज की गई वो दैट इज इनफैक्ट ऑन द बेसिस ऑफ द डिसीजंस ऑफ द सुप्रीम कोर्ट एंड सम स्टेट हाई कोर्ट आल्सो। That double recording is not necessary. You can consider the inquiry officer's record.
Okay.
But the judgments were also not being followed. So, in short, what I wanted to convey is that we must be very alert and aware of the legal provisions and very sensitive in attending the cases when it is particularly of a labor worker, workman.
Right, sir.
These all things can be taken care of even by the unions also, because union does not require, if a representative is attending the court, the workman can work in his industry, so that unnecessary leaves, everything that can be avoided. This is one part of it. So this collective representation, according to me, of the unions is very important. Now, so far as the grievances we'll now come to those points. What grievances any worker can place before the labor courts or industrial courts?
Mm-hmm.
The grievances generally in Schedule 5, the list is very illustrative, and attempt has been made to cover almost all types of unfair labor practices. So, but majority of the cases are regarding either the termination of an employee, transfer of an employee, and resultantly the question of his reinstatement also arises if if his termination is found to be illegal।
Mm-hmm.
देन रिटायर्ड प्रीमेच्योर रिटायरमेंट भी कभी कभी करते हैं एम्प्लॉयर, तो वो भी कवर होता है, वो टाइप का भी रिलीफ पे कर सकते हैं। और बैक वेजेस जनरली इफ द टर्मिनेशन इज सेट असाइड is prayed for, and that is, these grievances we are concerned how what principles are generally followed.
Mm-hmm.
So far as termination is concerned, the conduct should amount to a misconduct and breach of the rules in the appointment letter of that particular employee। उदाहरण के
Okay.
तौर पर बता सकता है, वो कोई एम्प्लॉय बार बार एब्सेंट रहता है विदाउट
Mm-hmm.
सबमिटिंग ए लीव एप्लीकेशन आल्सो, दैट इज
Mm-hmm.
सॉर्ट ऑफ मिसकंडक्ट। अब क्या
Mm-hmm.
हो गया है गवर्नमेंट सर्विसेज में या इवन इंडस्ट्रीज में, दिस थिंग ऑफ लिविंग एब्सेंट इज टेकन वेरी लाइटली, वेरी लाइटली। कोई ऐसा सोचा मैं बीमार गिर गया, मैं ये हो गया, मुझे वो हो गया, मेरी बेटी ठीक नहीं थी. सी, basically every employee should keep it in mind that he is for his employer. So this is a very important concept. This is maybe a philosophy, I can say, that every employee is for his employer. ही वो बीवी का भी नहीं है. When he accepts a service, तो वो बीवी का नहीं है, बच्चे का नहीं है. अब जब हम गवर्नमेंट ऑफिसर हम किसी ऊंचे ओहदे पे बैठते हैं तो हम कितना घंटे काम करते हैं. यू हैव सीन हाउ मच टाइम द
Right.
जजेस आर वर्किंग, राइट फ्रॉम
Hmm.
9 मॉर्निंग टिल नाइट, और घर पे जाने के बाद भी काम करते रहते. सो
Hmm.
व्हाई द वर्कर्स शुड नॉट गिव सच डेडिकेशन एंड डिवोशन. दिस इज वन एस्पेक्ट ऑफ देम. So therefore termination के बारे में now the courts are getting that way strict. The decisions which are coming up are not in the favors of workers nowadays that way. Misconduct of leaving absent, misconduct of doing any sort of immoral act in the premises of the industrial establishment. जैसे किसी औरत से, कोई मर्द किसी औरत से छेड़खानी करता है या बुरी नजर से देखता है, दिस इज एन इमोरल एक्ट ऑन हिज पार्ट. सो ये भी नहीं टॉलरेट किया जा सकता है. सो
Hmm.
टर्मिनेशन इवन कैन बी इन सच सिचुएशंस आल्सो. So
Okay.
therefore the employees have to be very cautious nowadays. So far as transfers are concerned, एम्प्लॉयर का हक रहता है एडमिनिस्ट्रेशन के लिए किसी भी एम्प्लॉय को एक जगह से दूसरी जगह पर ट्रांसफर करना. सो ट्रांसफर्स आर जनरली नॉट कंसिडर्ड एज अनफेयर लेबर प्रैक्टिस अनलेस it is specifically proved that there is some malafide behind transferring that employee. So that requires a very conclusive proof so far as transfers are concerned. So एक जमाने में ऐसा था कि लेबर कोर्ट में गए, ट्रांसफर कैंसिल हो गई. अब वैसा
Right.
नहीं रहा यार. हाँ, अब वैसा नहीं रहा. वी आर नॉट इवन मैंने एक केस चलाई थी, टाटा कंपनी की केस थे, और उन्होंने
Hmm.
कुछ महाराष्ट्र से म- नीचे काफी तमिलनाडु की उनमें उनके फैक्ट्री में कुछ वर्कर्स ट्रांसफर कर दिए थे.
Hmm.
तो इन लोगों का, जो महाराष्ट्र के जो एम्प्लॉय थे, उनका कहना था कि वी हैव बीन अपॉइंटेड इन टू वर्क इन द इंडस्ट्रीज at in Maharashtra only.
Okay.
There was at least, so far as appointment letter is concerned, there was no clear clause in it.
Hmm.
On the contrary, the clause was saying that the administrator, the employer will have a right to transfer the employee. इतना ही था. आउट ऑफ
Hmm.
स्टेट वगैरह के बारे में कोई रेफरेंस नहीं था.
Hmm.
फिर भी when the administration was able to prove that yes, their services were required at that particular place because the production was increased and there was not inadequate, there was inadequate stuff. So malafides were not proved. So transfers
Okay.
के बारे में law has become very strict. Now so far as reinstatement के बारे में भी I can say that reinstatement, even if the termination is proved to be illegal, रीइंस्टेटमेंट हर वक्त होगा ऐसा भी नहीं है.
Okay.
कुछ सालों के बाद अगर केस डिसाइड होती है, जैसे वो मैंने एक एग्जांपल आपको बोला, रिटायरमेंट के तकरीबन नजदीक भी नहीं मगर 5-6 साल या कुछ किसी भी वजह से प्रोलॉन्ग हो जाती है, ड्यूरिंग विच हिज पोटेंशियलिटी इज लॉस्ट,
Hmm.
तो भी वो ही कैनॉट बी रीइंस्टेटेड. सपोज एक एक वर्कर है जो हार्ड वर्क उसको करने के लिए बोला जाता है. इज मतलब उसके जॉब का जो नेचर है वो ऐसा है कि ही हैज टू वर्क वेरी हार्ड, एंड इफ ही
Hmm.
लूजेस दैट पोटेंशियलिटी,
Hmm.
तो ही विल नॉट बी रीइंस्टेटेड. अब कुछ वक्त reinstated on that post, or he can be reinstated on any lower post also. That is
Hmm.
possible. Reinstatement normally किया जाता है, मगर it is not necessary that in case of setting aside termination, the employee will be always reinstated. This is one
Okay.
thing. Then, so far as the premature retirement if it is held to be illegal, but एज मैंने वो एक पहले आपको एक केस बताई थी, जैसे वो 2 साल रहे थे उसके जो, तो ऐसे केस में भी अगर हिज पोटेंशियलिटी हैज बीन लॉस्ट, देन he may not be reinstated and his premature retirement can be maintained. बैक वेजेस के बारे में भी ऐसी पोजीशन है. बैक वेजेस जनरली द रूल इज दैट if there is no work there would be no pay. नो पे,
Okay.
नो वर्क नो पे इज द जनरल रूल.
Mm-hmm.
जब कोई आदमी काम करता है तो ही उसको पगार देने का सवाल आता है ना.
Right.
काम ही नहीं करता है तो पगार देने का सवाल ही कहाँ आता है.
Mm-hmm.
So even if his termination is held to be illegal, then also he will not be perhaps getting back wages 100%. अब
Okay.
लॉ इस तरह से डेवलप हुआ है कि it is the responsibility of the employee also to prove that during that period of termination he could not earn anything. अगर वो किसी दूसरी इंडस्ट्री में काम करता है, वहां उसको अगर कुछ रिम्यूनरेशन मिलता है, तो he will not be entitled perhaps to back wages. So in
Okay.
short, if there is no pay, there is no work, there is no pay. This is in short regarding the reliefs which can be granted by the labor courts. I think
Okay.
I must have exhausted the time. No, it
Mm,
is it's been
not at all, sir.
one
I have
hour,
one.
minute, so I should stop. Or if
No, no, no problem,
I
sir. We
can,
can go a little bit longer. Actually, it's interesting. I actually want to go a little bit longer, and I also have one
yeah,
question.
yeah. We can, you can ask questions. I think that would be then easy to others would be easily understanding it.
So back wages का provision नहीं है because no work, no pay. But अगर एम्प्लॉयर की वजह से मेरी जॉब चली गई है एंड इट इज बीइंग कंसिडर्ड एज अनफेयर ट्रेड प्रैक्टिस, तो जितने टाइम में आउट ऑफ वर्क था उसका जो जिम्मेदार है वो मैं नहीं, एम्प्लॉयर था. तो विल देयर बी एनी मॉनेटरी कंपनसेशन इन फॉर्म ऑफ
जनरली
पेनल्टी?
क्या होता है ऐसी केसेस में, एक 2-3 फैक्टर्स रहते हैं. जैसे एम्प्लॉय ने ये प्रूव करना चाहिए कि वो टर्मिनेशन के पीरियड में वो कुछ भी काम नहीं कर सका एंड दैट देयर वाज नो अदर पेमेंट अवेलेबल टू हिम.
ओके.
एक इस बात का एविडेंस उसने लाना है. दूसरी बात उसने ये भी साबित करनी है कि उसने कोशिश की दूसरा जॉब ढूंढने की, मगर उसे दूसरा जॉब नहीं मिल सका.
नहीं मिला.
ये भी उसने प्रूव करना है. और तीसरी बात एम्प्लॉयर ने प्रूव करनी है कि इस व्यक्ति को ये दूसरी एस्टेब्लिशमेंट पर पे ये काम कर रहा था और उसको इतना पगार मिल रहा था. दिस विल हैव टू बी प्रूव्ड बाय द एम्प्लॉयर. ये तीनों चीजों पर निर्भर रहता है किस प्रकार का रिलीफ देना. रिलीफ 25% से 100%, कभी कभी 100 में से 25% बैक वेजेस दिए जाते हैं, कभी 50% दिए जाते हैं, कभी 60% दिए जाते हैं. इट डिपेंड्स ऑन ये जो 3 फैक्टर्स पे जिस प्रकार का एविडेंस आया है उस पर निर्भर रहता है.
ओके. सो अदर देन बैक वेजेस देयर इज नो मॉनेटरी कंपनसेशन, मतलब इन फॉर्म ऑफ पेनल्टी ऐसा कुछ?
रहता है ये जैसे इलीगल रिट्रेचमेंट हो या इलीगल जो जो प्रोविजन सेक्शन 25 में इंडस्ट्रियल डिस्प्यूट्स एक्ट के आए हैं. देयर आर वेरियस डिफरेंट सिचुएशंस इन विच कॉम्पेंसेशन इज गिवन.
ओके.
Suppose if a if an employee is terminated without giving notice, so उसको 3 महीने का उस 3 महीने की नोटिस उसे देना कंपलसरी रहता है. तो उसे वो 3 महीने की सैलरी का कॉम्पेंसेशन देना पड़ेगा. There are some additional compensation beyond back wages. There are some compensation which are allowed
ओके.
in certain typical situations or facts of the case.
And is there a compensation for mental agony as well?
Yeah, that is also permissible. That is also, if say termination is found to be absolutely illegal without any reason, absolutely out of malice and malafide, then
Mm-hmm.
perhaps all reliefs can be given. Even 100% back wages can also be given. It depends
Okay.
on the facts of every case.
Sir, we've got one off-topic question regarding gratuity. Uh, if an employee works for 5 years but has not attended more than but was not present more than 200 days in any year, is he eligible for gratuity?
नहीं ग्रेजुएटी के लिए 5 साल पूरा पूरा उसका रेगुलर सर्विस होना इज बहुत
Okay,
नेसेसरी.
one very interesting
अगर
question.
यस यस
इसी से
यस.
मुझे याद आया. Some employers have this practice of terminating their employees off on paper and reappointing them maybe the same day, so that it would create an official break in their continued service of 5 years, and they could not pay gratuity.
It's then such as this is a technical break. It is not counted. It will, if the dispute arises, no, it will be treated as a continuous service.
Okay, okay, got it, sir. You were saying, sir?
So, one more see, by the judgment of the Supreme Court, very different, which is not contemplated under any act. One situation arises that
Hmm.
if any employee is committing such misconduct that his presence for a day also is not tolerable,
Hmm.
even if he is subjected to any inquiry by the employer, inquiry is likely to take some time, during which he may be suspended. But even his such type of prison, when he is suspended, no, he has a right to attend the premises of the industry. His attendance in the premises is also not tolerable. इस
Okay.
हालात में ऐसे हालात में the provision that has been made by the Supreme Court is that you can straightway terminate him, reserving your right, employer's right, to defend before a court of law if the
Okay.
employee files any complaint in the labor court or industrial court. This is one.
this would happen, फॉर एग्जांपल किसी ने चोरी किया, कुछ ऑफिस प्रॉपर्टी
Hmm.
चोरी किया,
Hmm.
तो the employer knows they can prove that he stole the things and all. और
Habitual thief thief है समझो वो
राइट,
habitual not one single incident हमेशा
तो
करते रहता है तो
तो
इस
इस
प्रकार.
केस में 3 महीने का नोटिस देना वुड बी रिस्की, क्योंकि वी
Yeah,
नेवर नो व्हाट एल्स he
yeah,
or she will steal. Yeah,
yeah.
understood.
So this is in sort of relief. Now, so far as the powers which the labor courts have, no, as I have discussed, they are summary inquiries. So the labor courts, though, are considered as judicial officers and courts, for, even for the purposes of the Contempt of Courts Act. Also, they are to conduct the inquiries before them in a summary way, like the administrative orders which are passed. One very nice judgment I have come across, which is in respect of the Trust Act cases, but the nature of the inquiry is similar.
Okay.
Administrative order, quasi-judicial order, and judicial order. Three different types are there.
Mm-hmm.
Now, orders in civil cases, criminal cases, orders in Trust Act cases, Labor Act cases, or other administrative issues, इन सब के डिसाइड करने के प्रिंसिपल्स अलग अलग है. This has
Okay.
to be remembered by all of us. In a criminal case, test of conclusive evidence is required. Case has to be proved beyond reasonable doubt. In a civil case, it is decided on on the probabilities. मतलब probabilities का मतलब ये कि कौन सी बात हो सकती है या कौन सी
Mm-hmm.
बात नहीं हो सकती. दिस इज प्रोबेबिलिटी.
Mm-hmm.
एविडेंस एक्ट के सेक्शन 3 में एक व्याख्या की है, डेफिनेशन की है कि व्हाट इज ए फैक्ट प्रूव्ड. बहुत ये पॉइंट मुझे अच्छा नहीं, हमेशा अच्छा लगता है बताने के लिए. व्हाट इज ए फैक्ट, व्हेन कैन इट बी सेड दैट ए फैक्ट इज प्रूव्ड.
Mm-hmm.
इसका आंसर जो दिया है सेक्शन 3 के डेफिनेशन में, ए फैक्ट विच appears टू बी ट्रू टू एनी मैन ऑफ रीजनेबल प्रूडेंस इज सेड टू बी ए फैक्ट ट्रू। हिंदी में इसका अगर भाषांतर करने जाए तो ऐसा है कि एक किसी भी बात एक आम आदमी को जो अच्छी तरह जिसकी सोच है उसे सच लगती है, वो बात सिद्ध हो हुई है, ऐसा मानता है कोर्ट।
Mm-hmm.
My Hindi is that way not very effective, but I have tried to. So
Mm-hmm.
यही प्रिंसिपल लेबर कोर्ट्स ने भी रखना चाहिए आंखों पे, उनके आंखों के सामने, क्योंकि
Okay.
हर बात को हम डॉक्यूमेंट्री एविडेंस से या विटनेसेस के एविडेंस से नहीं सिद्ध कर सकते। मगर कई बार एक डिफरेंट टाइप ऑफ एविडेंसेस, मतलब डॉक्यूमेंट्री हो, विटनेसेस हो, ओरल विटनेसेस हो, आने के आपके सामने आने के बाद आपको अगर लगता है कि यस दिस इज ट्रू, हाँ उसमें डाउट करने के लिए बहुत सारी वजह भी हो सकती है, मगर लेबर कोर्ट विल कंसिडर ए केस ओनली ऑन द बेसिस ऑफ इट्स ऑब्जेक्टिव सेटिस्फैक्शन। उसे
Okay.
लगता है कि यस हिज प्रूडेंट माइंड अलाउज हिम टू थिंक दैट यस दिस इज ट्रू, सो उसे उसको
Hmm.
एक्सेप्ट करना चाहिए। इट्स अ वेरी सिंपल process of appreciation of evidence should be followed in the labor courts. I think with this, if any questions are there, we can discuss.
Sir, so far there were only two questions from our members. Yep, only two questions, sir. And मैंने भी मेरे सारे पूछ लिया and I'm quite satisfied. Thank you so much, sir. I mean,
मैं थोड़ा सा घड़ी की तरफ भी देख रहा हूँ, इसलिए I am there.
नहीं नहीं,
Otherwise, there are many things to be discussed. But I think this time limit also must be there.
yeah, time limit. Unfortunately, there is a time limit, but I would definitely have love to have another session. उसमें कोई ifs and buts है ही नहीं, sir. थैंक यू सो मच सर, आपने टाइम दिया एंड ऑन बिहाफ ऑफ होल एलएलए टीम एंड एक्सक्लूसिव मेंबर्स वी थैंक यू अलॉट। एंड आपने एक बहुत अच्छी बात बोली जो मुझे बहुत अच्छी लगी। दो बातें एक्चुअली, एक तो ट्रायल एंड एरर से नहीं अप्रोच, ट्रायल एंड एरर अप्रोच नहीं फॉलो करनी चाहिए। इफ समवन इज अ लॉयर और इफ समवन इज अ जज, उनकी एक रिस्पॉन्सिबिलिटी बनती है कि टू डाइव डीप इनटू द सब्जेक्ट मैटर एंड बिकम एक्सपर्ट्स, ताकि जिसने कंप्लेन की है उसका सोल्यूशन ढंग से मिले, जल्द से जल्द मिले। एम्प्लॉयर की गलती नहीं है तो वो जल्द से जल्द प्रूव हो, क्योंकि काफी बार आपने भी बताया इवन वी कीप गेटिंग दीज केसेस की बहुत लंबा केस चल रहा है, या फिर डिसीजन ही ढंग से नहीं आया, या फिर केस का हुआ क्या वो कुछ पता ही नहीं है, बहुत सारी चीजें हैं। दूसरी आपने बात ये बोली कि जब जजेस इतने घंटे काम करते हैं, जब जो हायर अथॉरिटीज पे लोग होते हैं वो बहुत घंटों के लिए काम करते हैं पर डे, एंड वो राइटली सेड वो बीवी का भी नहीं है वो इंसान। तो जो लो लेवल एम्प्लॉयज होते हैं उनमें इतना डेडिकेशन यूजुअली देखा गया नहीं आता, एंड दे फील एंटाइटल्ड कि शाम को 7 बज रहा है या 8 बज रहा है तो आई दिस इज माय टाइम टू गो होम, एंड some in some ways they are right, but then at the same time they also have to understand कि no work no pay वाला सिस्टम। एंड उसका मेजर रीजन मुझे ये लगता है कि जो हायर अथॉरिटी पे लोग पहुंच पाते हैं अपने करियर में, दे आर द पैशनेट पीपल, दे आर डूइंग व्हाट दे लव। एंड जो लोअर लोअर अथॉरिटी पे जो ज्वाइन करते हैं, फॉर एग्जांपल हमारे कंट्री में इतनी बड़ी प्रॉब्लम है अनएम्प्लॉयमेंट की, तो आजकल जिसको जो भी काम मिल रहा है वो ले लेता है, रिगार्डलेस ऑफ कि उसको काम पसंद है या नहीं है। ऐसे केसेस में देखा गया है कि बहुत ऐसे लैक ऑफ डेडिकेशन मिलता है, वो काम सिर्फ इसलिए कर रहा है कि एट द एंड ऑफ द मंथ दे गेट अ पे चेक। तो आई थिंक इसको, दिस हैज टू बी राइट इन ऑर्डर फॉर द डेडिकेशन टू कम बैक। दैट्स व्हाट आई फील। नॉट एवरीबॉडी हैज यू नो लग्जरी टू डू व्हाट दे लव।
नहीं, जो भी
ये
देखो, ये बात नसीब की रहती है।
हम्म,
जिसके कोई कुछ इंटेलिजेंट होने के बावजूद भी उसके नसीब में अगर वही जवाब लिखा है, तो हम कई बार देखते हैं कि our peons are also sometimes very intelligent. Our
राइट।
stenographers are our stenographers. Sir, I would like to just by way of fun tell you that sometimes I have seen the judges getting the judgments typed from their stenographers. This is because they believe that their stenographer is competent to write a judgment.
राइट, एग्जैक्टली।
this is not a mistake, because the judge has tremendous workload. He knows that this type of judgment my stenographer even can. जैसे वो
Right.
अब्राहम अब्राहम लिंकन की एक स्टोरी है ना, कुछ ऐसे कि वो एक सभा में उनको जाना रहता है, तो वो नहीं जा जा पा सकते थे, तो उन्होंने कुछ कुछ दिक्कत थी उनको, तो उन्होंने खुद को ऐसा ड्राइवर के भेस में उन्होंने वो अपीयर हुए,
Mhm.
और फिर उसको ड्राइवर को बोला तू अब्राहम लिंकन करके खड़ा हो जा। देयर वर सम सिमिलैरिटीज बिटवीन देम। तो
Okay.
वो ड्राइवर स्पीच दे रहा था, कुछ सवाल ऐसे आए कि वो वाज नॉट इन ए पोजीशन, तो बोलता है
Mhm.
उस ड्राइवर पीछे ही जानबूझ के उन्होंने अरेंजमेंट की थी। वो मैं क्या इसका जवाब तो बहुत आसान है, मेरा ड्राइवर भी दे सकता है। ऐसी एक इंटरेस्टिंग ये है उनकी, तो वैसा है।
Yeah, that's the other side of the story कि employer has to appreciate the
हाँ,
employee's work. मतलब
या
he has to let them know कि यार आपकी वैल्यू है हमारी कंपनी में, you are just not some guy who is working and all. तो सामने वाले को भी मोटिवेशन आता है कि my boss thinks highly of me and he respects me. तो उसका डेडिकेशन फिर आने लगता है whether or not he likes the nature of job or not.
एग्जैक्टली। सो
Right.
स्मूथ रिलेशंस यही है ना, यू द
Right.
एम्प्लॉयर ऑल्सो अप्रिशिएट। एक छोटा
Mhm.
काम भी अगर उसको उत्तेजना दी जाती है, तो हिज डेडिकेशन एंड डिवोशन कैन इंक्रीज।
True. True, sir.
दैट इज इन फैक्ट द ट्रू स्पिरिचुअलिटी। सिर्फ पगार के लिए उन्होंने भी काम नहीं करना है, और इन्होंने भी अगर कोई अच्छा काम करता है तो उसको लो पे नहीं देना चाहिए एम्प्लॉयर्स ने।
True,
दिस इज
sir.
व्हाट
Rightly said.
यस।
So I think, sir, it's time to wrap up, and I
थैंक
hope
यू।
we get to see you soon.
आई विल ऑलवेज बी रेडी फॉर गिविंग। थोड़े से जो हिंदी बोलने वाले हैं, उन लोगों ने मुझे माफ, मैंने जो बोला है कि हम लोग हिंदी बोल सकते हैं, मगर दैट वर नॉट वेरी फ्लुएंट। कोशिश की
I'm sure,
मैंने।
I'm sure everybody loved it, sir. ऐसा नहीं है कि कोई इंग्लिश नहीं बोल पाता. It's just that हमारा जो मेन यूट्यूब चैनल है,
हिंदी 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 के बारे में बोल रहा हूँ। हिंदी
right,
हिंदी
right.
मुझे इतनी नहीं सही है।
Mm-hmm.
In fact, while closing, I say that judges are not good orators. It is said because they are listeners better.
Right.
So thank you
ठीक है,
very
sir.
much. Thank
Thank you so much for giving us your time, and I will
thank you,
surely be in
Pankaj.
touch.
Thank you. Thank you. Yeah.
Okay, sir. Good night.